38,000 కిలోమీటర్స్ మాత్రమే తిరిగింది. ఏ పార్ట్ మాట్లాడు షోరూంలో హిస్టరీ చెక్ చేసుకోవచ్చు.
Sir, good evening.
Good evening, very good.
Good evening, sir.
ఇంకా కాసేపు చూద్దామంటారా?
యా ఒక 2-3 మినిట్స్ చూసి స్టార్ట్ చేసేద్దాం సార్.
సరే.
ఎందుకంటే మనకి ఎగ్జామ్స్ ఇంకా ఆగలేం. మళ్ళీ ఇది అయినాక మన నోట్స్ కూడా చదువుకోవాలి కదా సార్.
అవునవును, అది కూడా చదవాలి.
టూ మచ్ వర్క్ ఉంది మనకి.
అవునండి, కంటిన్యూస్ గా ఉంది.
టైం లేదు, టూ మచ్ వర్క్. ఒక 2 మినిట్స్ చూద్దాం.
అలాగే, సరే.
సార్ స్టార్ట్ చేద్దామా?
స్టార్ట్ చేయండి. యాక్చువల్గా నేను ఒక 2 days అటెండ్ అవ్వలేదు కదా, అవి నేను తర్వాత చూడాలైతే.
ఓకే.
అంతకు ముందువి
అవి వీడియోస్ ఉన్నాయి సార్.
అట్లాగే నేను చూస్తానులేండి తర్వాత.
Yeah.
ఇప్పుడు స్టార్ట్ చేయండి.
సో యాక్చువల్లీ ఈచ్ టాపిక్లో సార్ మనకి లాంగ్ సెక్షన్స్, ఇప్పుడు బిఎన్ఎస్ఎస్ ఇవి అనుకోండి, దెర్ ఆర్ 15 or 16 సెక్షన్స్. సో మనం ఐ థింక్ దెర్ ఆర్ 7 sections which we have finished, subsections, and then we are coming to the 8th one. So 8th one వచ్చేసరికి this is nothing but a charge. A charge is a formal document specifying the offense allegedly committed by the accused. Framing of charges is a critical issue. The trial proceeds based on charges framed. So, ఒక్క నిమిషం, 1 minute, I'll just drink some water. Yeah, sorry. Okay. So, this section is basically charges. Charges ante enti ani. A charge is a formal document specifying the offense allegedly committed by the accused. So, framing of charges is a critical stage. Typically, what happens is framing of charges, మనము చార్జ్ షీట్ తీసుకొచ్చి కోర్టులో వేసినప్పుడు court will actually ask both the parties, not both the parties, so the accused actually, మీరు ఈ క్రైమ్ చేశారా లేదా అని అడుగుతారు అనమాట. నేను చేయలేదు అన్నప్పుడు the court will go ahead and starts doing framing of charges, which is basically they'll write the questions. అంటే ఈ క్రైమ్ యాజ్ పర్ దిస్ సెక్షన్ ఈజ్ ఇట్ ఈయన చేశాడా లేదా. సో ద ఎంటైర్ కేస్, ఇప్పుడు మనం 3 కోట్ల ఫ్యాక్ట్స్ ఇన్ ఇష్యూ రాసాం కదా, సో అలా ద ఎంటైర్ కేస్ రివాల్వ్స్ అరౌండ్ దోస్ క్వశ్చన్స్ అనమాట. ఓకే. సో what are the sections which are relevant to charges? For section 211 CrPc, it basically contents of charge must specify offense, particulars of the offense, name of the person against whom offense is committed. So charges లో ఏముండాలి, అసలు ఏం offense చేసాడు, particulars ఏంటి, name of the person ఉండాలి. And 212 particularly states the particulars as to time, place and person ఉండాలి. And 213లో when the matter of committing offense must be stated. Manner అంటే ఎలా ఈ క్రైమ్ని కమిట్ చేశాడు అనేది కూడా చెప్పాలన్నమాట. Important illustrations of section 212: when the accused is charged with theft of a public article at a specified time and place, the charge need not state the manner in which the offense was committed. In contrast, for offenses requiring specific peculiar circumstances, kidnapping, cheating or by force, the manner must be specified. సో ఇప్పుడు సింపుల్ థెఫ్ట్ ఉందనుకోండి, అందులో మేనర్, స్టేట్ ఆఫ్ ద మేనర్ అవసరం లేదు. బట్ ఇప్పుడు చీటింగ్, కిడ్నాపింగ్, ఫోర్స్ అవన్నీ ఉంటాయి కదా, అంటే దే ఆల్రెడీ ప్రీ ప్లాన్ చేసి ఉంటారు కదా, అప్పుడు ఏంటంటే యూ హ్యావ్ టు మెన్షన్ దమ్, స్టేట్ ద మేనర్ ఇన్ విచ్ ద offense was committed అనమాట. సో ద ఎగ్జాంపుల్, ఏ is accused of theft of certain article at a certain place and is a case where manner of committing the offense is not required. And then discharge of accused, okay, section 227, and which is in sessions court, and section 239. So basically discharge petition is something where you can put it in the lower court or in the higher court. So once the charge sheet comes to the court, the accused can say, సార్ అసలు ఇందులో ఎవిడెన్సే లేదు, ఇది ఫాల్స్ కేసు వేసారు నా మీద, అంటే without the trial happening. So look at on the face of it, just look at all the evidence that has been given by the police and everybody, and based on the documents you can decide whether there is a case or not. So దీనికి ఏం చేస్తారంటే, you have to do that basically on the which is basically section 239. Lower court lete section 239 prakaram వేసుకోవాలి. Warrant case on police report. If upon considering the police report and the documents sent, under section 173, and after hearing both sides, the magistrate considers the charge against the accused to be groundless. He shall discharge the accused with the reasons recorded. The same thing about a discharge petition, you can put in sessions code also, where it is section 2 to 7. If upon consideration of the record of the hearing the parties, the judge considers there is no sufficient ground for proceeding against the accused, he shall discharge. Okay. So under section 239,
అంటే
the
ఇది
magistrate
డిశ్చార్జ్ పిటిషన్ వేయాలంటారా డైరెక్ట్ గా వాళ్ళు డిశ్చార్జ్ చేసేస్తారా?
డిశ్చార్జ్ పిటిషన్ వేయాలి సార్.
ఓకే.
లేకపోతే వాళ్ళు డైరెక్ట్‌గా ఇది ఎప్పుడు ఈ డిశ్చార్జ్ ఇంపార్టెంట్ థింగ్ ఏంటంటే సార్, ఫ్రేమింగ్ ఆఫ్ చార్జెస్ ఇందాక అనుకున్నాం కదా! ఈ క్వెషన్స్
అవును.
ఫ్రేమ్ చేసే ముందే ఎయ్యాలి. అంటే మీరు ఫ్రేమింగ్ ఆఫ్ చార్జెస్ అయినాక డిశ్చార్జ్ పిటిషన్ ఎయలేం.
ఓకే.
దెన్ అది ట్రయల్ అయిపోతుంది.
హ్మ్.
దెన్ హీ లూజెస్ హిస్ అంటే ఆన్ ద ఫేస్ ఆఫ్ ఇట్ చేయలేడింకా. ఫ్రేమింగ్ ఆఫ్ చార్జెస్ అయితే ట్రయల్ అయినాకే వాళ్ళని అక్విట్ చేస్తారనమాట.
హుహు.
దట్స్ అక్విటల్. అండ్ దిస్ ఈజ్ డిశ్చార్జ్. సో ఇప్పుడు సెక్షన్ 239 ప్రకారం డిశ్చార్జ్ పిటిషన్ వేసుకొని వాళ్ళు ఇప్పుడు ఇలాగే టైం పాస్ చేస్తారు కదా సార్ వీళ్ళు. సో బేసికలీ చార్జ్ షీట్ రాగానే డిశ్చార్జ్ పిటిషన్ వేస్తారు. డిశ్చార్జ్ పిటిషన్ వచ్చేదాకా ట్రయల్ ఆగిపోతుంది. సో
ఓహో!
ఆ డిశ్చార్జ్ పిటిషన్ లేదు ట్రయల్కి వెళ్ళాలి అన్నారు అనుకోండి, మళ్ళీ సెషన్స్ కోర్టులో వేస్తారు.
హుహు.
సో అదే ఒక 3-4 ఏళ్ళు తినేస్తుంది. సెషన్స్ కోర్ట్ ఏమంటది, లేదు ట్రయల్ అవ్వాల్సిందే అందనుకోండి, మళ్ళీ దాన్ని ఏం చేస్తారు, మళ్ళీ తీసుకెళ్ళి హైకోర్టులో వేస్తారు, సుప్రీం కోర్టులో వేస్తారు. సో ఈ డిశ్చార్జ్ పిటిషన్కి 4-5 ఏళ్ళు చేసేస్తారు. లేదు సుప్రీం కోర్టు కూడా లేదు ట్రయల్ అవ్వాల్సిందే అన్నారు అనుకోండి, ట్రయల్ అవుతూ ఉంటుంది. ట్రయల్ అయినప్పుడు విట్నెస్లు ఇవన్నీ బేసిక్గా అప్పటికి 4-5 ఏళ్ళు అయిపోతుంది కదా సార్, విట్నెస్లు కొనేయటం, లేకపోతే
ఆ!
ఇన్వెస్టిగేషన్ ఆఫీసర్ వెళ్ళిపోతాడు వేరే చోటకి.
కరెక్ట్.
సో అంతా దాని హీట్ తగ్గిపోద్ది అనమాట. బట్ ఇంపార్టెంట్ థింగ్ ఈస్ ఫ్రేమింగ్ ఆఫ్ చార్జెస్ కన్నా ముందే వేయాలి సార్. సో discharge is not an acquittal, sir, which you have to understand. Discharge is nothing but on the face of it, you are saying that there is no enough evidence.
అదే బిఫోర్ ఫ్రేమింగ్ ఆఫ్ చార్జెస్.
Before framing of charges. సో ఇక్కడ ఆల్టరేషన్ ఆఫ్ చార్జ్. సో ఆల్టరేషన్ ఆఫ్ చార్జ్ ఎలా చేయొచ్చు? కోర్ట్ మే ఆల్టర్ ద చార్జ్. ద కోర్ట్ మే ఆల్టర్ or add a charge at the time before judgment is pronounced. Alteration must be read and explained to the accused. If the alteration is likely to prejudice the accused, the court may direct a new trial or an adjournment. So additions or alteration of charges is provided under section 216, which is exam tested. So basically ఏంటంటే alteration of charges, ఇప్పుడు ఆయన మీద సెక్షన్ 420 పెట్టాము, 418 పెట్టాము, 419 or 406 పెట్టాము. కోర్ట్ ఏమంటుందంటే బేస్డ్ ఆన్ ద ఎవిడెన్స్ ఇది 420 కింద రాదు, 408 కింద వస్తుంది. సో దే హ్యావ్ ద థింగ్ టు చేంజ్ ద చార్జ్ అనమాట, ఆర్ ద సెక్షన్. బట్ ఆ చార్జ్ మీరు జడ్జ్మెంట్ లోపల ఎప్పుడైనా చేయొచ్చు. జడ్జ్మెంట్ ముందు చేస్తే మాత్రం ట్రయల్కి మళ్ళీ ఛాన్స్ ఇవ్వాలి మన అక్యూజ్డ్కి.
మళ్ళీ న్యూ ట్రయల్ చేయాలి.
న్యూ ట్రయల్ చేయాలి. సో కొన్ని నాకు తెలిసిన ఇష్యూస్ ఏంటంటే, కొన్ని చోట్ల ఏమవుతుందంటే వీళ్ళు సెక్షన్ 420తో పాటు కార్పొరేట్ చీటింగ్ అయిందనుకోండి సార్, సో 420తో పాటు 408 పెడతారు. బట్ సమ్టైమ్స్ వాట్ హ్యాపన్స్ ఈస్ 408 ఈస్ ఫర్ ఐ థింక్ డైరెక్టర్స్ ఆఫ్ ద కంపెనీ అండ్ 409 ఈస్ ఫర్ ఎంప్లాయీస్ ఆర్ సంథింగ్ లైక్ దట్. సో అప్పుడు ఏం చేస్తుంది కోర్టు, వాళ్ళు సమ్టైమ్స్ ఏం చేస్తారు, డిఫెన్స్లోకి వెళ్ళిపోయి అసలు ఈ 408 అప్లికబుల్ కాదండి, ఎందుకంటే ఆయన అసలు ఫుల్ టైమ్ డైరెక్టర్ కాదు, హీ వాజ్ జస్ట్ అన్ ఎంప్లాయీ అని చెప్తారు.
ఓకే.
దానికి జడ్జ్ ఏం చేస్తాడంటే ఇమీడియట్గా ఆల్టరేషన్ చేసి 408 కాకపోతే 409 పెట్టండి అంటాడు, ఎంప్లాయీ కదా.
ఓకే.
సో అప్పుడు ఫ్రేమింగ్ ఆఫ్ చార్జెస్ అప్పుడు చేసుంటే అది ట్రయల్ మధ్యలో చేశారనుకోండి, దెన్ డూ ద రీట్రయల్ ఆఫ్ దట్ అగైన్ అన్నమాట. సో జాయిండర్ ఆఫ్ చార్జెస్, ఏ చార్జ్ ఫర్ వన్ ఒఫెన్స్. బేసికలీ సేమ్ థింగ్ మన సివిల్ కోర్టులో లాగా, వన్ చార్జ్ ఫర్ వన్ ఒఫెన్స్. సెక్షన్ 218. Section 219 says 3 offences of same kind within 12 months may be tied together. Within 1 year వాడు థెఫ్ట్ ఇవి అవి కిడ్నాపింగ్ అన్ని చేస్తే ఒక సింగిల్ కేసులో దాన్ని చేయొచ్చు. acts forming part of the same transaction must be tied together. So basically, same transaction అంటే ఒక ఇంట్లో మర్డర్ చేశారు, థెఫ్ట్ చేశారు, డెకోటీ చేశారు, అన్నీ చేశారు అంటే ఇఫ్ దే హ్యావ్ డన్ ఆల్ ఆఫ్ దాట్, then it can be part of the same transaction or multiple transactions. Whether it is doubtful what offense has been committed, accused may be charged with all. So whether it is doubtful what offense has been committed, accused may be charged with all. సో డౌట్ఫుల్ ఉన్నప్పుడు అన్ని చార్జెస్ ఇవ్వచ్చు అనమాట. అండ్ సెక్షన్ 223 జాయిండర్ ఆఫ్ అక్యూజ్డ్ హూ కెన్ బి ట్రైడ్ టుగెదర్. అంటే మల్టిపుల్ రోల్స్ ఉన్నప్పుడు సిమిలర్ రోల్స్ ఉన్న వాళ్ళని దే కెన్ బి ట్రైడ్ టుగెదర్ అనమాట. So coming back to our exam thing, important thing is section 211 contents of the charge. 212 ఏంటంటే particulars of time, place, person ఉండాలి. Manner not required for simple thefts. 213 is nothing but manner in which it is committed. And 216 alteration or addition of charges at any point. 227 discharge of sessions. 239 discharge of magistrate. And 218 is one charge for one offense. Exception is 219. So question bank ఏంటంటే additions or alteration of charges is provided in CrPc. So additions or alteration of charges is provided under CrPc. So answer basically additions, alterations ఏ CrPc కింద వస్తాయి అని అడుగుతున్నారు. సో ఇందాక మనం నేర్చుకుందా addition alteration 216 కింద వస్తుంది. 216 కింద వస్తుంది. Okay, and next question ఏంటంటే under section 239 the magistrate can do what? ఇందాక మనం చదువుకున్నాం కదా సెక్షన్ 239 ద మెజిస్ట్రేట్ కెన్ డిశ్చార్జ్ a magistrate in warrant case. సో ఈ అండర్ సెక్షన్ 239 ఈ కెన్ సే దీంట్లో అసలు కేసే లేదు, ఐఎమ్ డిశ్చార్జింగ్ ద పర్సన్. ఓకే, అండ్ నెక్స్ట్ విచ్ ఆఫ్ ద ఫాలోయింగ్ కేసెస్ manner of committing offense is not required to be mentioned in the charge as per Code of Civil Procedures. A accused of theft of certain article, of cheating, disobeying, A is accused of giving false evidence. So దేంట్లో ఏంటంటే సింపుల్ క్రైమ్స్ కి మేనర్ అవసరం లేదు. సో ఐ థింక్ థెఫ్ట్ ఇస్ థెఫ్ట్ సరే. సో విల్ గో టు ద నెక్స్ట్ సెక్షన్. సార్ ఇది చార్జెస్ అయిపోయాయి. we'll go to the next section, which is basically trial procedures. So trial procedures lo basically CrPc and BNSS provide for different type of trials based on the nature of the offense. So there is a sessions trial, there is a warrant trial, there is a summons trial and a summary trial. Each of it has its own procedures. So ఇది చాలా ఇంపార్టెంట్ ఎందుకంటే ఇవి 15 ప్రీవియస్ ఇయర్ క్వశ్చన్స్ ఉన్నాయి. సో సెషన్స్ ట్రయల్ ఏంటంటే వాట్ ఈస్ సెషన్స్ ట్రయల్? సో సెషన్స్ కోర్టు ఎప్పుడు అయితే ట్రయల్ చేస్తుంది, ఎప్పుడు చేస్తుంది అంటే వెన్ సంథింగ్ ఈజ్ డెత్, మర్డర్ చేశారనుకోండి, ఆర్ ఎనీథింగ్ ఇంప్రిజన్మెంట్ గ్రేటర్ దెన్ 7 years ఉన్నప్పుడు ఈ సీరియస్ కేసు లోవర్ కోర్ట్కి ఇవ్వటం ఎందుకు అని సెషన్స్ ట్రయల్ చేస్తారనమాట. సో లైఫ్ ఇంప్రిజన్మెంట్, డెత్ ఉందనుకోండి, అది సెషన్స్ కోర్టే ఇవ్వాలి. సో వారెంట్ ట్రయల్, సో విచ్ ఈస్ బేసికలీ వారెంట్ ట్రయల్ ఈజ్ సెక్షన్ 238 పనిషబుల్ విత్ ఇంప్రిజన్మెంట్ గ్రేటర్ దెన్ 2 years. సో ఎనీథింగ్ దట్ ఈస్ పనిషబుల్ విత్ ఇంప్రిజన్మెంట్ గ్రేటర్ దెన్ 2 years మెజిస్ట్రేట్ ఆఫ్ ఫస్ట్ క్లాస్ చేస్తారనమాట. దెన్ దెర్ ఈస్ సమన్స్ ట్రయల్. సో లెస్ దెన్ 2 years పనిష్మెంట్ ఉంటే మెజిస్ట్రేట్ అంటే సింపుల్ థెఫ్ట్ ఆర్ సంథింగ్ ఎల్స్ where you have a summons trial, then you'll less than 2 years ఉంటే చేస్తాం. Summary trial, specific offenses, quick procedure. ఈ summary trials like basically I think check bouncing or vehicle తాగొచ్చేసి మనము కోర్టుకి వెళ్ళినప్పుడు చూసాం కదా, సమ్మరీ ట్రయల్స్ చేశారు. ఫస్ట్ క్లాస్ మెట్రోపాలిటన్ మెజిస్ట్రేట్ కోర్ట్ చేస్తారు అనమాట. So coming into the details, Code of Session murder cases, section 302, IPC with death or life is exclusive trial. So basically section 302 unte Court of Sessions ke ellali. Okay, that is as per the CrPc procedure. A magistrate cannot try a murder case. So a murder case is tried on the Court of Session. Okay, this is very important. And next, cases triable by different courts. So children below 16 years for offences not punishable with life under Section 27 deals with jurisdiction of Court of Sessions or Chief Judicial Magistrate regarding offences children under 16 years. So a juvenile aged 14 years brought before the court for an offence not punishable with under Section 26 CRPC is also. So another thing is, a child below 16 years for offences not punishable with death or life. And since it is a very sensitive matter, since they are kids, and since the court is allowing them to be going through the trial, then the trial has to be conducted with a court of session or chief judicial magistrate. So it cannot be done by first class magistrate, as per Section 27 of CRPC. Next to summons trial, which is basically death of complainant. In summons case instituted on a complaint, if the complainant does not appear or has died on the fixed date, the magistrate shall acquit the accused, unless he thinks proper to adjourn the hearing for some reason. So in summons trial or complaint, the non-appearance or death of complaint results in acquittal of the accused. So it's an important thing. Summons case ఎందుకంటే అవి చిన్న చిన్న కేసులు less than 2 years. సో అదర్ పార్టీ ఎవరైతే కంప్లైంట్ ఇచ్చారో వాళ్ళు కనపడిపోయినా వాళ్ళు చనిపోయినా ఆటోమేటిక్గా అక్యూజ్డ్ విల్ బి ఎక్విటెడ్. Section 256 of CRPC. Then evidence of prosecution, Section 242 specifically deals with evidence of prosecution in warrant cases instituted on public report. After charges are framed, the magistrate proceeds to take evidence for the prosecution. Okay. So Section 242 basically deals with evidence for prosecution in warrant cases. And in camera trial. So Section 327, which is amended in Section 366 of BNSS, mandates the trial for offences under Section 376, that is rape and sexual offences agreement, shall be conducted in camera, not in open court, and as far as practicable by women judge. So in camera trial is conducted in cases charged under Section 376 of IPC, which is exemption, dispensing with personal attendance. Section 205 CRPC empowers the magistrate when issuing a summons to dispense with personal attendance of the accused if he sees reason to do so and permit him to appear by his pleader. సో సెక్షన్ 205 ఏంటంటే మెయిన్ పర్సన్ ఉండనక్కర్లేదు, మీకు వీళ్ళు ఉంటే చాలు, లాయర్స్ ఉంటే చాలు, వాళ్ళు చూసుకుంటారని చెప్తారు. సెక్షన్ 260 పవర్ టు ట్రై సమ్మర్లీ. సో సమ్మరీ ట్రయల్స్ ఏంటంటే సెక్షన్ 260 హూ కెన్ ట్రై following the magistrate certain offences summarily, basically any so sessions chief judicial magistrate can do, metropolitan magistrate can do, any magistrate for first class, and all of these can do a summary trial. Offences for trial summarily including those not punishable with death, life imprisonment for term exceeding 2 years. Originally the limit was 1 year, raised to 2 years. Some specifically offences like theft, cases up to a value, criminal trespass. సో థెఫ్ట్ ఒక వాల్యూ కింద థెఫ్ట్ అయితే లెస్ దెన్ 2 years పనిష్మెంట్ ఆర్ క్రిమినల్ ట్రెస్పాస్ వీటన్నిటికీ సమ్మరీ ట్రయల్ చేసేయచ్చు అనమాట. సో ద వాల్యూస్ ఇక్కడ క్లియర్గా ఇచ్చారు. 2000 కన్నా తక్కువ ప్రాపర్టీ థెఫ్ట్ అయితే, రిసీవింగ్ స్టోలెన్ ప్రాపర్టీ, ఇన్సల్ట్ విత్ ఇంటెంట్ టు ప్రొవోక్, క్రిమినల్ ఇంటిమిడేషన్, ఇవన్నీ ఏంటంటే లెస్ దెన్ 2 years కాబట్టి ఇట్ షుడ్ బి ఓకే, సమ్మరీ ట్రయల్ చేసేయచ్చు. The important thing is language. Section 272 of CRPC, state government has the power to determine the language of the court other than the High Court within the government. So it's very important. Why are trials not done in Telugu or Hindi or in local languages in India? It is not a central government subject, but it is a state subject. Each state has the power to determine the language of the courts other than the High Court within a given state. సో హైకోర్టును వదిలేసి మిగతా కోర్ట్స్లో ఏ లాంగ్వేజ్ ఉండాలి అనేది అది మన స్టేట్ గవర్నమెంట్ జ్యూడిస్డిక్షన్. ఇట్ ఈస్ నాట్ ఏ సెంట్రల్ గవర్నమెంట్ జ్యూడిస్డిక్షన్. సెంట్రల్ గవర్నమెంట్ ఆర్ ద చీఫ్ జస్టిస్ కెన్ డిఫైన్ హై కోర్ట్స్ అండ్ సుప్రీం కోర్ట్స్లో ఏ లాంగ్వేజ్ యూజ్ చేయొచ్చు. So there is another concept called de novo trial. A de novo trial is a fresh trial ordered when the original trial has been vitiated by serious irregularities going to the root of the cause. The Supreme Court has consistently held that a de novo trial should be the last resort. ఒరిజినల్ ట్రయల్ is serious irregularities ఉన్నాయి అన్నప్పుడు it is called a de novo trial. A fresh trial is ordered. So very rarely that is done. It has to be done as last resort. It is orderly only in exceptional circumstances where the original trial cannot be cured. When the trial court lacks jurisdiction, where there is a fundamental violation of natural justice. ఈ దీంట్లో de novo trial అయిపోతుంది. ఓకే, నెక్స్ట్ క్యూరింగ్ ఇర్రెగ్యులారిటీస్. సో క్యూరింగ్ ఈ ఇర్రెగ్యులారిటీస్ ట్రయల్లో క్యూర్ చేయనప్పుడే de novo అవుతుంది. క్యూర్ చేయగలిగే కెపాసిటీ సెక్షన్ 465 వస్తుంది. సో క్యూర్ మీన్స్ వాట్? Section 465 provides that no finding, sentence, or order passed by the court of competent jurisdiction shall be reversed merely on account of any error, omission, or irregularities in the proceedings, unless, in the opinion of appellate court, the error has occasioned a failure of justice. So, an irregularity like reading and recording of evidence taken in one case into another case can be cured by Section 465. Okay. సో ఇంపార్టెంట్ థింగ్ is reading and recording of evidence. ఒక కేసులోంచి ఇంకొక another companion కేసులో తీసుకున్నప్పుడు provides no failure of justice has been resulted, which can be cured అనమాట. అంటే అక్కడ ఎవిడెన్స్ ఇక్కడ తీసుకోవడానికి and doing multiple things, then you can do the curing of irregularities using Section 465. So what are the new things that BNSS had added? One of the things is they did trial procedures lo section 356 అక్కడ తీసుకొచ్చారు. That means allowable for trial in absentia of proclaimed offenders. So this is very important. సో offender లేకుండా ట్రయల్ చేయలేము అనేవాళ్ళు కదా. సో విజయమల్ల వెళ్ళిపోయి అక్కడ కూర్చున్నాడు, ఇప్పుడు ఆయన మీరు ట్రయల్ చేయలేమన్నారు కదా. న్యూ లా ప్రకారం ఆయన ఉన్నా లేకపోయినా allowable of trial in absentia of proclaimed offenders where the accused has absconded and there is no immediate prospect of arresting him. అప్పుడు ఆయన లేకుండా కూడా ట్రయల్ చేయొచ్చు. This is an important thing which they've added in BNS. And Section 530, electronic mode trials. Facilitate trials and proceedings to be held in electronic, enabling virtual hearings and digital court proceedings. So this is something which they've added, virtual hearings, digital court proceedings. So add చేశారు. COVID-19 తర్వాత దీన్ని సీరియస్గా తీసుకున్నారు. Section 346 is restrictions on adjournments. Places restrictions on adjournment of trials, providing that no adjournment shall be granted merely because of pleader's absence, aimed at ensuring expedite resolution of cases. So typically pleader రాలేదు కాబట్టి adjournment ఇస్తారు కదా, ఇప్పుడు అది allowed కాదని చెప్తున్నారు 346. So these are the three innovations which is in BNS, which is not there in CrPc. Okay, so summarizing sessions trial is section 2 to 5. Greater than 7 years. Warrant trial is basically lower court, first class magistrate, less than greater than 2 years. Summary trial is less than 2 years. Summons trial. Summary trial is for petty offences. So murder is always done in court of session. Section 27 is where children under 16 years jurisdiction of sessions court. Section 205 magistrate may dispense with personal appearance of the accused. 242 is evidence for prosecution in warrant case. 256 non-appearance, death of complainant in summons trial. 260 summary trial. Okay, summary trial offences less than 2 years of imprisonment. And language defined is section 270 of CrPc and section 327 and 366 in camera trial చేస్తారన్నమాట, especially during in case of rape. De-novo trial is last resort. 465 irregularities, not vitiating proceedings. 356 is trial in absentia, 530 is trial in electronic mode, and 346 is restrictions and adjournments. Okay. So important questions in the Indulo. So in camera trial is conducted in cases charged upon what? So basically 376 IPC is rape. So which is what we should be using. Okay. Next, which of the following authority, which is a authority that determines the language of the court? Language of the court with us given in the state is under section 271 of CrPc, which is basically what? Which is only state government. You have to remember that language of other than High Court is determined only by state government, not by central government or both. So one thing which you have to remember is the provision, same provision BNS law section 267 కింద ఉంది. So unfortunately, I've seen the syllabus లో రెండు ఉన్నాయి, BNSS ఉంది, CRPC కూడా ఉంది. So we have to study both for the exam. So they might ask in CRPC or in BNS. Section 272 in CRPC and 267 in BNSS. Which of the following deals with evidence of prosecution? Evidence of prosecution is section 242. Deals with evidence of prosecution, warrant cases instituted on a public report. Okay. Which of the following offences may be tried summarily as per the Code of Civil Procedures? Offences under section 454 or offences under section 504, offences punishable with imprisonment not exceeding 2 years, or official punishment life is imprisonment. So basically less than 2 years is the one. Okay. A juvenile aged 14 years is brought before the court for an offense not punishable with death or imprisonment. Under which provision of code will the case primarily fall? Juvenile తీసుకొస్తే సెషన్స్ కోర్ట్ వెళ్ళాలి, అది సెక్షన్ 27 of CRPC అవుతుంది. And magistrate may dispense with personal attendance on accused under section. అంటే accused రానక్కర్లేదు, వాడు ప్లీడర్ వస్తే చాలు. That is section 205 of CRPC. Which of the following cases can be cured under section 465 of the Code of Criminal Procedure 1973? So which of the following cases? And entertaining of complaint without complying with section 195-340, the reading and recording of evidence taken in one case into another case, the examination of witness in absence of accused. So 465 is nothing but joinder of 465 in the చదువుకున్నాం కదా, joinder of accusations and ఇవి. So సివిల్ మ్యాటర్లో జాయిండర్ రీజాయిండర్ లాగా ఇక్కడ సెక్షన్ 465 ఈజ్ నథింగ్ బట్ జాయిండర్. ఎస్పెషలీ ఇట్ ఈస్ యూస్డ్ వెన్ ఎవిడెన్స్ ఇన్ వన్ కేస్ కెన్ బి యూస్డ్ ఇన్ అనదర్ కేస్. It is defined in section 465. So the answer is B. Which of the following statements hold true for de novo trials? De novo trials ante if the original trial cannot be cured, అన్ని irregularities ఉన్నాయి అన్నమాట, a fresh trial has to be done. So what is the answer? Omission or irregularity in proceeding, even if it does not affect the core of the case, can become a ground. A de novo trial should be the last resort. The court originally trying the case can order de novo trial, none of these. So basically, de novo trial is the last resort. Same court చెప్పలేదు. And omission, irregularity of procedure also cannot affect the core of the case. Since it is not affecting the core of the case, it cannot be a de novo trial. Okay. Which of the following has the power of summary trial of a case? So who has the power? So Chief Judicial Magistrate, Metropolitan Magistrate, any magistrate of first class, especially hardware. So all three have the power as per section 260. So in summons trial case instituted on a complaint wherein the summons have been issued to accused, the non-appearance or death of a complaint shall entail the acquittal of the ఇందాక చదువుకున్నాం కదా, సమ్మన్స్ కేసులో ఎవరైతే కంప్లైంట్ ఇచ్చారో వాళ్ళు కనబడిపోయినా వాళ్ళు డెత్ అయిపోయినా ఆటోమేటిక్ ఎక్విటల్ అయిపోతుంది. Which section of BNS allows for trials in absentia of proclaimed offenders? So basically, which section deals with this is the new section in BNSS కదా, like విజయమాల అనుకున్నాం 356, ఆయన లేకపోయినా ట్రయల్ చేయొచ్చు. And which of the following facilitate trial proceeding with electronic mode? Section 530 is also an innovation. Which of the sections BNSS restricts on adjournment of trials, ensuring expedition resolution in cases? So leader రానప్పుడల్లా adjourn చేయటము is not allowed. So it is under BNS 346, which is a new one. Which of the following courts under criminal procedure can try a murder case? So murder case is always sessions, court of session. No? BCI keyలో D ఉందంట, but answer is C. Next, which of the following courts under criminal procedure can try a murder case? Which is basically court of session. This is a repeat question. I think they were asked the same in AIB 14 and AIB 2 times అడిగాడు సేమ్ క్వశ్చన్. Stupid fellow. Okay. Next topic is judgment and sentencing. You want me to go ahead, sir? Hello.
చదవండి.
Yeah.
లేకండి ఇంకా
Okay.
వేరే ఎవరన్నా చదవమంటారా? హేమాలి గారు చదువుతారా?
పర్లేదు సార్, నేను చదువుతానులేండి, నో ఇష్యూస్. ఇది ఒకటి చదువుతాను, దాని తర్వాత చూద్దాం.
I can
అంటే
read. Okay.
Okay, ma, I'll just finish the 10, then you can read from there. Okay.
Okay.
11 you can do. Okay. So, the another topic is judgment and sentencing. So, judgment is the final decision of the court after trial. Sentencing allows conviction. CrPc and BNSS describe limits in sentencing power of different courts. So, Section 28 of CrPc, High Court may pass any sentence authorized by law. And Section 28, a Sessions Court or additional sessions may pass any sentence authorized by law, but a sentence of death passed by such court is subject to confirmation by High Court. So the Court of Session can pass any sentence authorized by law, but the death sentence requires HC confirmation. High Court confirmation kavali. 28(3) Assistant Sessions Judge may pass any sentence authorized by law except the sentence of death, imprisonment of life, and imprisonment of term exceeding 10 years. So Assistant Session Judge may pass a sentence of imprisonment up to 10 years. 10 years దాకానే చేయొచ్చు. అంటే ఫస్ట్ క్లాస్ జడ్జ్లు వీళ్ళంతా ఉంటారు కదా, మెట్రోపాలిటన్ సెషన్స్ కోర్ట్ జడ్జ్, వాళ్ళు maximum 10 years. Sessions Court can do anything except death sentence. High Court confirm చేయాలి. High Court can pass any judgments. So sentencing powers, 29(1), a Chief Judicial Magistrate may pass any sentence authorized by law except for sentence of death, sentence of imprisonment of life, and sentence of imprisonment of terms exceeding 7 years. So the CJM may pass a sentence of imprisonment not exceeding 6 years. Is basically a Chief Judicial Magistrate. ఈయనకి ఏం పవర్స్ ఉన్నాయి, చీఫ్ జ్యుడిషియల్ మెజిస్ట్రేట్ ఏం పవర్స్ ఉన్నాయి అంటే, ఎక్సెప్ట్ దీస్ సెంటెన్స్ ఆఫ్ డెత్, సెంటెన్స్ ఆఫ్ ఇంప్రిజన్మెంట్ ఆఫ్ లైఫ్, సెంటెన్స్ ఆఫ్ ఇంప్రిజన్మెంట్ ఫర్ నాట్ ఎక్సీడింగ్ 7 years. సో CJM మే పాస్ ఎ సెంటెన్స్ ఆఫ్ ఇంప్రిజన్ నాట్ ఎక్సీడింగ్ 7 years. ఇది అసిస్టెంట్ జడ్జ్ అంటే సెషన్స్ కోర్ట్ జడ్జ్, డిస్ట్రిక్ట్ జడ్జికి అసిస్టెంట్ ఉంటారు కదా, ఆయన 10 years దాకా చేయొచ్చు. చీఫ్ జ్యుడిషియల్ మెజిస్ట్రేట్, ఇది మెట్రోపాలిటన్ జడ్జ్, లోవర్ కోర్ట్స్ ఉంటాయి కదా, అందులో చీఫ్, మళ్ళీ అందులో చీఫ్, నార్మల్ జడ్జ్ కూడా కాదు, చీఫ్కే 7 years ఉంది. బిలో చీఫ్ జ్యుడిషియల్ మెజిస్ట్రేట్ ఈజ్ అ నార్మల్ ఫస్ట్ క్లాస్ మెజిస్ట్రేట్. ఆయనకి ఏంటంటే హీ కెన్ పాస్ ఇంప్రిజన్మెంట్ అప్ టు 3 years ఆర్ ఫైన్ నాట్ ఎక్సీడింగ్ 10 years ఆర్ బోత్. సో a magistrate of second class is basically 1 year, fine not exceeding 5,000. So if you sum it up, ఎందుకంటే కోర్ట్ ఆఫ్ సెషన్స్ కోర్ట్ పైన ట్రయల్స్ అవ్వవు, అంటే హైకోర్టులో ట్రయల్ అవ్వదు, ఆర్ సుప్రీంకోర్టులో ట్రయల్ అవ్వదు. సో సెషన్స్ కోర్ట్ ఈస్ ద హైయెస్ట్ కోర్ట్ వేర్ ద ట్రయల్ కెన్ హ్యాపెన్. అండ్ సెషన్స్ కోర్ట్లో అయిన ట్రయల్స్కి ఎనీ సెంటెన్స్ ఇవ్వచ్చు except for death where you need HC confirmation. Assistant Sessions Judge unte ఆయనకి 10 years, Chief Judicial Magistrate 7 years, Magistrate of first class 3 years ఉండాలి, 10,000. Second class is 1 year and 5,000. This is the maximum they can do అనమాట. So what is imprisonment in default of fine? So the court of magistrate may award such term of imprisonment in default of payment of fine. So in a fine కట్టలేకపోతే దానికి కూడా they can say term of imprisonment పెంచుతారు అనమాట. The term of imprisonment is default shall not exceed the powers of magistrate under section 29. So term shall not exceed 1/4 of the term of imprisonment which the magistrate is competent to inflict as substantial punishment. So if a magistrate sentences a person for 2 years imprisonment and a fine, the maximum term of imprisonment in default for payment of fine is 6 months, which is basically 1/4 of 2 years. Okay. So important thing ఏంటంటే, ఇప్పుడు ఈ మెజిస్ట్రేట్ ఫస్ట్ క్లాస్ 2 years అండ్ ఇంప్రిజన్మెంట్ ఫైన్ వేసారు. ఫైన్ నేను కట్టలేను అన్నాడు. ఫైన్ కట్టలేనప్పుడు వాళ్ళు 1/4 of 2 years, maximum term is 1/4 of 2 years ఇవ్వచ్చు. That is 2 years plus that shall not exceed 1/4 of term which the magistrate is competent to inflict. So if a magistrate sentence 2 years imprisonment and a fine. The maximum term of imprisonment in default of payment. In default of payment is basically 6 months. So a total 2 years or 6 months అవుతుంది. And this should not also exceed this 3 years. ఇప్పుడు ఆయన 3 years పనిష్మెంట్ ఇచ్చి ఫైన్ ఇచ్చాడు అనుకోండి, ఆ ఫైన్ కట్టలేకపోయినా maximum will be only 3 years only. Because the first rule says the term of imprisonment shall not exceed the power of magistrate under section 29. The power of first class magistrate is only 3 years. Okay, so this is some exam tested where they'll ask the question. ఇప్పుడు ఆయన ఫైన్ కట్టలేదు అన్నప్పుడు ఆయన 2 years మీరు పనిష్మెంట్ వేస్తే 1/4 ఆఫ్ దట్ అంటే 2 years డివైడ్ బై 1/4 is 6 months. 2 years ఫైన్ కట్టినందుకు 6 months యాడ్ చేయాలన్నమాట. You guys understood, right?
Yes, I think so.
Okay. So then pronouncement of judgment, which is basically section 353, judgment shall be delivered in open court. Judgment can be delivering the whole argument orally, reading out the whole judgment, reading out only the operative part and explaining the substance in a language understood by the accused or his pleader. So under section 353, all 3 modes, delivering whole, reading whole, or reading operative plus explaining are valid. ఓకే, ఆయన ఓన్లీ జడ్జ్మెంట్ ఓవరాల్గా చెప్పాడు, డెలివరింగ్ రీడింగ్ ఆయన ఓన్లీ రీడ్ చేసాడు, లేకపోతే ఓన్లీ కొంచెమే చదివాడు అంటని లేదు. ఈ 3 ఆల్ ఆర్ వ్యాలిడ్. సో కమ్ బ్యాక్ టు ద ఎగ్జామ్, బేసికలీ లెట్స్ సమ్ ఇట్ అప్. Section 28 Sessions Court, any sentence, death. Section 28 Assistant Sessions Judge 10 years, and Chief Judicial Magistrate 7 years, Junior First Class Magistrate maximum 3 years, Junior Second Class Magistrate maximum 1 year, 5,000, 10,000, 5,000. Imprisonment default of fine not more than 1/4 of substantial max. Okay, then judgment in open court, whole read out or operative part, and death reference should be section 366 should be given to High Court confirmation involvement. So come back to the questions. Judgment, there are like 6 questions in the last 10 years. Which of the following sentences is an assistant sessions judge authorized to pass as per the code of civil procedure? So assistant judge and district judge ki kinda assistant. ఆయనకి basically sentence not exceeding 10 years, which is basically ఇందాక చదువుకున్నాం కదా 10 years ఉంటుంది ఆయనకి. 10 years దాకా ఇవ్వచ్చు ఆయన పనిష్మెంట్. Next, as per section 30 of the Code of Civil Procedure, if the magistrate sentenced a person to 2 years imprisonment and a fine, what is the maximum imprisonment he may impose in default of the payment? So this is a in the calculate చేసాం కదా, 2 years imprisonment, వాడు ఫైన్ కట్టలేడు, సో 1/4 of 2 years. The answer is 6 months. So sometimes they may say, what is the total? Total number 2 years కూడా యాడ్ చేయాలి, 2 years and 6 months and right. Under section 29 of CrPc, the court of chief judicial magistrate may pass any sentence authorized by law except what? Except who is he? First chief judicial magistrate అయినా. Chief judicial magistrate అంటే first class magistrate పైన ఉంటారు, అంటే ఆయనకి 7 years. So what he can accept అంటే except what he can do, what he shouldn't be doing. Sentence of death చేయలేడు, imprisonment of life చేయలేడు, imprisonment for term exceeding 7 years ఈ 3 చేయలేడు. So answer is all of the above. The equivalent section for that is section 23(1) of BNSS. ఈ క్రిమినల్ కోడ్లో దరిద్రం ఏంటంటే మనకి CrPc చదవాలి, BNSS కూడా చదవాలి, 2 చదువుకెళ్ళాలి. A chief judicial magistrate may pass a sentence of imprisonment. Chief judicial magistrate ఆయనకి 7 years ఉంటుంది, not exceeding 7 years. Which of the following sentence can a court of session pass? Court of sessions is the highest form of trial, so they can pass anything, which is maximum is death kada. So answer any sentence authorized. So important ఏంటంటే డెత్ ఇచ్చాడు, rigorous imprisonment, simple imprisonment ఇచ్చాడు. Actually it is any sentence kada, so you should answer should be D. It is any sentence that is authorized by law. This is a tricky question. Okay, చూడగానే డెత్ సెంటెన్స్ పెట్టిస్తారు అనుకోండి, యాక్చువల్లీ ఆన్సర్ ఇస్ D. Next, judgment should be delivered to parties or to the pleaders in open court. So దీనికి 3 methods ఉన్నాయి. ఒకటి, he can do an oral one, he can deliver the whole of judgment by reading out the whole of judgment or reading a part of the judgment. So all of them are true. ఇది గుర్తుంచుకోవాలి మీరు. Okay. So there ends judgments. The next topic is appeals, reference and revision. ఎమ్మెల్యే గారు మీరు చదువుతారమ్మా?
Yeah, I'll read it, sir. All right. Appeals, reference, and revision. CrPc provides 3 distinct mechanisms: appeals, references, and revisions. For what? And for review of the criminal court orders. Reference and revisions are restricted in scope. Okay, appeals 372 to 394 of CrPc. 372 general rule intended: no appeal shall lie from any judgment or order of a criminal court except as provided by CrPc or any other law. Okay, key appeal sections are 374, 376, 377, 78, 79. Oh, okay, 74 is appeals from the convictions, that is High Court, Sessions Court, or Magistrate. Then 376 is no appeal in petty cases. 377 is appeal by state government against inadequacy of sentence. 378 is appeal in case of acquittal by the state or complainant with leave for Supreme Court. 379 is appeal to the Supreme Court in certain cases where the High Court has reversed the acquittal or convicted. I think we are going higher and higher with the sections. Okay. Reference to the High Court. Section 395 of CrPc provides for reference to the High Court by a subordinate court where a court is satisfied that a case pending before it involves a question as to the validity of any act, ordinance, or regulation. It may refer the question to the High Court for opinion. So provision for the reference to High Court is 395 of CrPc. Provision for reference to the High Court is 395 of CrPc. This has been exam tested. BNSS equivalent is in section 434. Okay. And revision at 397 to 405. So important we 397, 401, 482. 397 is High Court or Sessions Court may exercise revisional powers against any order of any inferior criminal court. 401 is High Court's powers of revision. High Court's power of revision is 401. 482 is inherent powers of the High Court, often invoked to quash the criminal proceedings. That is revision. Reference to High Court appeals. Okay. So forfeiture of newspapers, limitation for application is 96 clause 1 CrPc. Any person having an interest, as we read this, I think, any person having an interest in a newspaper, book, or any other document may within 2 months from the date of application apply to the High Court to set aside a declaration of forfeiture made under section 95. A note on AIBE 20 question 33. The assertion was that any person having an interest in a newspaper can apply. This is true under section 96 clause 1. The reason in the question evidently misstated the time period or any other detail. BCI marked it as A. The takeaway here is under section 96, the application will be filed within 2 months. You have to remember this 2 months. Any person having an interest in a newspaper, book, or any other document within 2 months from date of application will apply to the High Court to set aside a declaration of forfeiture. This is under section 95. And ఇది ఎందుకు వచ్చింది ఇక్కడ? Forfeiture of newspapers, limitation of application.
Forfeiture of newspapers అంటే sometimes ఏమవుతుందంటే ఈ search and దీంట్లో we have search and seizure లో sometimes they seize the newspapers or books and things like that, right? సో వాళ్ళు ఏంటంటే అవి టైం బౌండ్ ఉంటుంది కదా. సో పబ్లికేషన్స్ ఏమన్నా చేశారనుకోండి, వాళ్ళు హైకోర్టుకి వెళ్ళి దే కెన్ అపీల్ సేయింగ్ దట్ మేము ఈ బుక్లో ఏమీ ఇల్లీగల్ అన్కాన్స్టిట్యూషన్ ఏమి పబ్లిష్ చేయలేదు.
Oh, okay. Okay.
And then they can take those things back.
Okay. Okay. So I'll go to the first question.
Yeah.
First is which of the following sections of Code of Criminal Procedure 1973 provide for reference to the High Court? Section 395 provides for reference to the High Court. Where is it? 395. Yeah, I think the 3.11.2. This has been exam tested. We have to remember this. 395 of CRPC provides for reference to the High Court, where a subordinate court is satisfied that a case pending before it involves a question as to validity of any act. Then it shall state a case setting out its opinion, refer the same for the decision to the High Court. So second question is given below are two statements, one labeled as assertion and one labeled as reason. Assertion is any person having an interest in the newspaper declared forfeited may apply to the High Court to set aside the declaration within 2 months of its publication in the official gazette. Reason is the special bench of the High Court to hear such application must always consist of exactly 3 judges, regardless of the strength of that High Court. So here answer is A is true. A is true, we already read this. R is false. So under we know this now, section 96 clause on CRPC. Reason is incorrect. Why reason is incorrect? Because section 96 clause 2 provides that the special bench shall consist of 3 judges, or where the High Court consists of fewer than 3 judges of all the judges of that court. Understand? The special bench of the High Court to hear such application will always consist of exactly 3 judges. Okay. Or whether High Court was fewer kuda undachchu. High Court was fewer than 3 judges of the okay. Hence the bench is not always exactly 3 judges regardless of the strength of the High Court. Okay. Ante. So that is given in section 96 clause 2. Fewer than 3 judges kuda undachchu. Exactly AV, that is not this one. Mark exactly. So that's why R is false. 3.112 is maintenance of wife, children, and parents. Section 125 CRPC or Section 144 of BNSS is a key provision for maintenance. A secular statutory remedy enabling neglected wives, children, parents to claim monthly allowance from a person of sufficient means who refuses to or neglects to maintain them. It is recognized as one of the most socially important sections in CRPC. What is that? 125 CRPC or 144 of BNSS. Maintenance of wives, children, and parents. 3.12 whatever is scope of section 125. Scope ఏంటంటే a magistrate of the first class may, upon proof of sufficient means and neglect or refusal to maintain, order a person to make a monthly allowance for the maintenance of his wife who is unable to maintain herself. Second is his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, and his legitimate or illegitimate adult child, not being a married daughter, where such child is by reason of any physical or mental abnormality unable to maintain itself. And the fourth one is his father or mother unable to maintain himself or herself. These are the 4 this conditions where this will apply 125 of CRPC. ఇది ఎవరు చేయగలుగుతారంటే మ్యాజిస్ట్రేట్ ఆఫ్ ఫస్ట్ క్లాస్. ఓకే. Wife when disentitled. So section 125 clause 4 of CRPC expressly provides that no wife shall be entitled to receive maintenance from her husband if she is living in adultery or without sufficient reason she refuses to live with her husband or they are living separately by mutual consent. So if a wife voluntarily refuses to live with her husband without any sufficient reason, she is not entitled to maintenance. This is exam tested. We have to remember this. So wife doesn't want to live with the husband. There's no reason for that also. So she's not entitled for maintenance. Okay. So next is removal of the 500 rupee cap. 2001 amendment. Originally 125 CRPC capped a maintenance of 500 rupees per month. Oh my God. I think, that time probably it was a big sum, I think. The Code of Criminal Procedure, Amendment Act of 2001 removed the ceiling, leaving the quantum of maintenance to the discretion of the magistrate, subject to the means of the husband and the needs of the dependent. Means of the husband and needs of the dependent. This is the this one. How they decide on the maintenance. So the maximum limit of 500 rupees was removed in 2001. This was also exam tested. We have to remember this. 2001, they removed the ceiling of 500 rupees per month as maintenance. Secular secular character, Muhammad Ahmad Khan versus Shah Banu, is a famous Shah Banu case where the Supreme Court held that 125 CRPC maintenance is secular in character. It applies to all the citizens irrespective of religion, including divorced Muslim women. So the court held that 125 section is a secular provision designed to prevent vagrancy and destitution, and personal laws, including the Muslim personal law, cannot override the obligation under section 125. So a divorced Muslim woman is entitled to maintenance under section 125 even after the iddat period, if she is unable to maintain herself. Subsequently, legislative response: Muslim Women Protection of Rights on Divorce Act of 1986 initially limited maintenance for Muslim women to the iddat period plus a fair provision. Subsequent Supreme Court rulings in Daniel Latifi 2001, Supreme Court read this act consistently with section 125 CRPC, resorting to secular protection. So Muslim personal law ni kuda override JCC, they have gone to they can seek protection under this secular law, which is this 125 CRPC. So the observation that section 125 CRPC is secular in character was given in this case of Muhammad Ahmad Khan versus Shah Banu Begum. This was also exam tested. Okay, so the procedure in the application before the judicial magistrate of the first class, in place where the husband, father, or target person is, or where the wife, child, or parent resides, or where they last resided together. The magistrate may order interim maintenance pending the final order. Interim maintenance also can be claimed. So the order is enforceable by issuing a warrant for levying the amount if the amount remains unpaid. The person may be sentenced to imprisonment up to 1 month for each month of arrears. 1 month for each month of arrears. Okay. Order may be altered under section 127 if there's a change in circumstance. Then, so exam tips are section 125 CRPC maintenance for wife, child, and parents. We have read this. Wife is disentitled for maintenance if living under adultery, refuses without reason. She doesn't want to live with the husband. There's no reason for that. Mutual separation, then also shall not be entitled for maintenance. 2001 amendment law, they removed the 500 cap. Muhammad Ahmad Khan versus Shabana Begum, section 125 is secular in character. Magistrate of the first class has the jurisdiction. Yeah, he has the jurisdiction. We read this from interim maintenance, all this. He can give orders. Imprisonment up to 1 month per month of arrears. 127 of CRPC, alteration of maintenance according to change in circumstance. Under which, so questions are under which the following situation wife is not entitled to maintenance under section 125 CRPC. Husband presumes that wife is living in adultery. Voluntarily, wife refuses to live with husband. Wife living separately, husband keeps a mistress, and wife is forcefully removed from the house. Not entitled is voluntarily wife refuses to live with the husband. This is the exact doesn't live with husband. You have to remember that. So mistress, that is not. I don't think it is given the section, so we cannot write that. So 125 clause 4 of CRPC 1973 expressly provides that no wife shall be entitled to receive maintenance from the husband if she is living in adultery. First ఇది కూడా అవుతుంది కదా, presumes that wife is, or if without any sufficient reason she refuses to live with the husband, or if they are living separately by mutual consent. First one is not A can't be the answer. My husband presumes wife is living in adultery. Everybody is so tired.
Husband is presuming It is not a fact.
Oh, it should be a fact.
So
Oh, presuming. Okay. Sorry.
tricky questions.
Husband presumes that wife is living in adultery. Okay. Sorry. So, a wife living separately, his husband keeps a mistress. Sorry. Okay. B, voluntarily, wife refuses to live with the husband or they're living separately. Voluntary refusal to live with the husband. This is also correct. No. Oh, yeah. Okay. Sorry. Disqualifies the wife from claiming maintenance. Answer is B. Voluntarily, wife refuses to live with the husband. So, I'll go to the next one. It's easy only.
Yeah.
2001. Maximum limit of rupees 500 deportation was removed in 2001 amendment. Okay.
Yeah, 2000.
Third one is 125 of CRPC secular. A case Mohammad Ahmed Khan was Shabana Begum.
Yeah.
So this is a secular provision. Shall I go to the next one?
Yeah.
Okay. So preventive provisions. CRPC contains preventive provisions distinct from trial provisions that empower the executive magistrates to take preventive action against potential offenders or sources of public disturbance without the need for a formal criminal trial. Executive magistrate అంటే ఎవరు కలెక్టర్సా?
Executive magistrate. No, executive magistrates అంటే మన ఫస్ట్ క్లాస్, సెకండ్ క్లాస్.
Okay. Executive magistrate is
చీఫ్ జ్యుడిషియల్ మేజిస్ట్రేట్.
chief judicial magistrate. Okay. ఎగ్జిక్యూటివ్ అంటే నేను ఎగ్జిక్యూటివ్ అనుకున్నాను. ఓకే. So security for keeping peace and good behavior. Section 106 to 110 of CRPC. These provisions empower the executive magistrates to require persons to execute a bond with sureties for keeping the peace or for good behavior for a specified period. Section 107, security for keeping the peace, where there is likelihood of breach of peace. 108 is security for good behavior from persons disseminating seditious matter. Distribution of newspapers, book containing seditious or obscene matter is 108. 109 is security for good behavior from suspected persons. Those taking precautions to conceal their presence with a view to committing a cognizable offense. The magistrate may require execution of a bond with or without sureties for good behavior for a period not exceeding 1 year. This was exam tested. I'll just read it again. Section 109 is security for good behavior from suspected persons, those taking precautions to conceal their presence with a view to committing a cognizable offense. The magistrate may require an execution of a bond with or without sureties for good behavior for a period not exceeding 1 year. 1 year. Okay. Next
Okay.
is 110. 110 is security for good behavior from habitual offenders. That previous one is suspected persons. This is habitual. Habitual robbers, housebreakers, thieves, forgers, kidnappers, fraudsters, receivers of stolen money, traffickers, and slave girls, habitual offenders against decency or morals, vagabonds, etc. So the magistrate may require execution of a bond for a period not exceeding 3 years. Habitual offender is 3 years, suspected persons is 1 year. So police can seek a bond for good behavior from habitual offenders in section 109 and 110. We already read now 109 and 110. This is exam tested. Security for good behavior from habitual offenders is specifically 110 of CRPC. This is exam tested again. Bond under 109 for suspected person maximum is 1 year. Again, exam tested. This is important. We have to remember this. Bond under section 110 for habitual offender maximum is 3 years. Next is removal of public nuisances. The 133 of CRPC empowers the executive
One
magistrate.
one second. You are right about the executive magistrate. Executive magistrates actually report to the executive state government, whereas the judicial magistrate reports to the court. So executive magistrates అంటే ఐఏఎస్ ఆఫీసర్స్, డిప్యూటీ కలెక్టర్స్, తహసీల్దార్స్.
Okay.
సో వాళ్ళకి లిమిటెడ్ పవర్స్ ఇచ్చారనమాట ఇవి ఆఫెండర్స్కి, సెక్యూరిటీకి, పీస్కి, గుడ్ బిహేవియర్కి. సో దే హ్యావ్ లిమిటెడ్ పవర్స్ vested in
Okay.
them.
Okay. So fine. Shall I read this? Removal of public nuisance. Yeah.
Yeah, yeah.
Removal of public nuisances. Section 133 of CrPc empowers the executive magistrate to make conditional orders. Conditional orders for the removal of unlawful obstructions or nuisance in public places, rivers, channels, trades or occupations injurious to health or physical comfort of the community, construction of buildings or disposal of substances likely to cause conflagration or explosions, buildings, tent structures likely to fall and cause injury, dangerous animals. So they can they can make orders to for the removal of all these things. Okay. Who can do that? Executive magistrates under section 133. Basically, this is under removal of public nuisances. So section 133 is a provision under which a citizen can file a public case in the court of magistrate regarding issues of public interest. This is public nuisance. Is also exam tested. The magistrate can issue a conditional order requiring the addressee to remove the nuisance or appear and show cause why the order should not be made absolute. After hearing the order can be made absolute. Section 136. Sorry, 129 to 132 is unlawful assemblies. So 129 is dispersal of unlawful assemblies by use of civil force. 130 is use of armed forces to disperse the assembly. First is civil force, probably I think this is the police, and this is armed forces. Versus 130. 144 is power to issue a order in urgent cases of nuisance or apprehended danger. Used to impose curfews, ban gatherings, etc. Exam tips law 107, section 107, security for keeping peace. 108 is security for good behavior. 109 bond, this is important. These three. This 109 bond for suspected persons. Max 1 year. Bond for habitual offenders is max 3 years. 110 adi. So police can seek a bond from habitual offenders on 109, 110. 133 is executive magistrate's power for removal of public nuisances. 144 urgent orders, curfew, gathering bans, etc. So first question under this is police can seek a bond for good behavior under section 109 and 110 of CRPC from habitual offenders, white collar criminals, jail inmates, none of the above is answer is habitual offenders. Okay. And next one is under which provision can a citizen file a public case in the court of magistrate regarding issues of public interest. 133. We read this note. 133. Executive magistrate's power for removal of public nuisance for public interest matters. Then third one is security for good behavior from habitual offenders is dealt under 110. Okay, 110. Then the bond under section 109 is it's for suspected persons. So suspected person is less time bond. So 1 year. Okay, the executive not exceeding 1 year. So shall I go to the next one?
Yeah. Since we don't have time.
Sorry, I'll just read this.
Yeah,
Small one
14 we'll finish. 15 we'll do tomorrow.
Sorry, plea bargaining and alternative dispute resolution. Plea bargaining is a mechanism by which an accused agrees to plead guilty. So accused is ready to plead guilty in exchange for a lighter sentence or settlement with the victim. This has been introduced to India by the Criminal Law Amendment Act 2005 as effective from 5th July of 2006, codified in chapter 21A of CRPC. So that is, it's a mechanism wherein accused agrees to plead guilty in exchange for a lighter sentence, okay, or any settlement with the victim. Statutory basis is 21A. Sections are 265A to 265L, inserted by the CrPc Amendment Act 2005, deals with plea bargaining. This is exam tested, okay. 265A to 265L, Chapter 21A of CrPc is related to plea bargaining. Eligible offences. Section 265A, Clause 1 of CrPc, plea bargaining is available for offences other than offences punishable with death, imprisonment for life, or imprisonment exceeding 7 years. So the inkit is not available. Plea bargaining is not available for this. Offences affecting the socio-economic condition of the country that is notified by the central government, and offences committed against a woman or offences committed against a child below 14 years. So plea bargaining is applicable only to offences with imprisonment up to 7 years. Okay. So woman, child below 14 years, socio-economic condition of the country, death, imprisonment for life, or imprisonment exceeding 7 years. Deentlo edi plea bargaining does not apply. You have to remember that. Plea bargaining is not applicable if the offence is committed against a child below 14 years. This is also exam tested. You already read this, but still. So C, both A and B is correct. Okay. So procedure for plea bargaining. Accused files an application for plea bargaining. Court examines the voluntariness of the application. Court may direct the parties to participate in mutually satisfactory disposition, which is nothing but like a settlement. So if an agreement is reached, the court may pass an appropriate order. 1/4 of the punishment provided for the offense, or half of the maximum punishment in cases not specifically provided. 1/4 or half. So compensation to the victim is provided for, and order is final and it is not appealable. Order is final, not appealable except by special leave petition. So time limit under the BNSS. So an application for this is given in 290, clause 1 of BNSS. So an application for plea bargaining must be filed within 30 days. 30 days from the date of framing of charges against the accused. So this is a new BNSS time limit. CrPc did not specify a time period. Sorry. 30 days you have to remember because it's exam tested. Compounding of offences given in section 320 CrPc deals with compounding of offences. For criminal intimidation, section 503 of IPC defines criminal intimidation. 506 of IPC prescribes the punishment. Under section 320 clause 1 CrPc, criminal intimidation under section 506 IPC is compoundable without court permission. CrPc, then IPC, PC, it's compoundable without court permission, which is also exam tested.
So one of the things which we have to understand is the time limit on the other. They have introduced that plea bargaining. So initially, starting low, we were talking about when the charge sheet comes to the court, discharge petition వేసుకోవచ్చు in the sense that దీంట్లో అసలు కేసులో there is no evidence only, sir. అసలు on the face of it, you can just close the case without even going for a trial. సో అది ఏం చేయాలంటే బిఫోర్ హీ హ్యాస్ టు డూ దట్ డిశ్చార్జ్ పిటిషన్ బిఫోర్ ఫ్రేమింగ్ ఆఫ్ చార్జెస్ పెట్టారు. సో మన మూట్ కోర్ట్లో రిమెంబర్ ఫ్రేమింగ్ ఫ్యాక్ట్స్ ఇన్ ఇష్యూ అని పెట్టుకున్నాం. ఫ్యాక్ట్స్ ఇన్ ఇష్యూ ఇస్ లైక్ 4 questions they'll ask, right?
Yes.
In a similar way, the judge will put 4 questions. As per this section, did he do this? Did he commit the crime? Did he kidnap? So the entire trial ఆ క్వశ్చన్స్ మీద నడుస్తుంది అనమాట.
ఓకే.
సో ఇప్పుడు ఏమంటున్నారంటే ఇందులో దిస్ గై కెన్ డూ ప్లీ బార్గెనింగ్ ఫ్రేమింగ్ ఆఫ్ చార్జెస్ అయినా కూడా చేసుకోవచ్చు వాడు. అంటే ఫ్రేమింగ్ ఆఫ్ చార్జెస్ ముందు ఏం చేస్తారంటే వాడిని తీసుకొచ్చి అరే నువ్వు ఈ క్రైమ్ చేసావా లేదా, ఎస్ అన్నాడు అనుకో, దెన్ డైరెక్ట్గా వాళ్ళు వాట్ ఎవర్ ఇస్ ద పనిష్మెంట్ దే విల్ పుట్. ఇఫ్ హి సేస్ నో, దెన్ ఓన్లీ ఫ్రేమింగ్ ఆఫ్ చార్జెస్ ఇస్ డన్.
Oh, okay.
సో అది ఫ్రేమింగ్ ఆఫ్ చార్జెస్ అయిన 30 days లోపల హీ హాస్ టు డూ ప్లీ బార్గెనింగ్.
Plea bargaining. Okay.
సో ఆల్రెడీ నేను చేయలేదని చెప్పి ఫ్రేమింగ్ ఆఫ్ చార్జెస్ స్టార్ట్ అయిపోయి ఫ్రేమింగ్ ఆఫ్ చార్జెస్ జడ్జ్ ఇచ్చేస్తారు కదా ఇద్దరు సైడ్కి, ఇవి క్వశ్చన్స్ దీని మీద మీరు మనం ట్రయల్ చేస్తామని.
Oh,
సో ఆ ఫ్రేమింగ్ ఆఫ్ చార్జెస్ ఇచ్చేసినాక 30 days లోపల దే హ్యావ్ టు డూ ప్లీ
do plea
బార్గెనింగ్.
bargaining. After that, he can't do.
Exactly.
That
That
is
is
the
given in
time limit.
section 290. Yeah.
290 clause. What is this one? This compounding of offense, section 320 CRPC. Only sections in IPC. It's
Criminal, I think there are some offenses which are compoundable, right? So basically we have studied initially what is compoundable and non-compoundable offense, right? Difference between compoundable and non-compoundable offense అనుకున్నాం కదా, గుర్తుందా?
compoundable are lesser offenses. No?
Compoundable means
Non-compoundable
severe.
serious. Non-compoundable serious.
Yeah, so less compoundable is less severe criminal act, right? సో
Yes.
అదేంటంటే మనం ఇప్పుడు మనం లోక్పాల్ అక్కడికి వెళ్ళాం కదా, వాట్ ఎవర్. సో కాంపౌండబుల్ ఒఫెన్సెస్ అక్కడ మనము అది లోకాయుక్తనో దెర్ వాజ్ సమ్ కోర్ట్ ఈవెంట్, రైట్? సాటర్డే.
We went to Rangareddy court, sir.
అవును, ఫస్ట్ టైం వెళ్ళాం కదా, అక్కడ ఓన్లీ సెటిల్మెంట్స్ అవుతున్నాయి చూడండి. దాన్ని ఏం కోర్ట్ అంటారు? లోక్ అదాలత్.
Lok Adalat.
సో
Yes.
కాంపౌండబుల్ ఒఫెన్సెస్ ఇద్దరు బోత్ ద పార్టీస్ కెన్ గో అండ్ సే లోక్ అదాలత్లోకి వెళ్ళి వాళ్ళు సెటిల్ చేసుకోవచ్చు, కానీ నాన్ కాంపౌండబుల్కి సెటిల్ చేసుకోవడానికి లేదు.
So was it serious?
It means it's serious, right? So compounding will be like simple hurt, defamation, or criminal trespass.
Okay. Okay.
Okay.
Yeah.
Non-compoundable are serious, which is basically murder or rape, cannot be settled privately. They require a full trial.
Okay.
So what you have to remember, compoundable ante private, ante it can be settled privately. Non-compoundable, it cannot be settled privately.
Okay. How to read this? Shall I read this or I think
Yeah, I think we are done. We're almost done with this. Or we have like 6 questions in it. We can quickly finish it off and then we can go tomorrow. Yeah.
Okay. Shall I read the differences?
Yeah.
Or should-
అవసరం లేదండి, ఇందాక చదివేశారు కదా.
I'll just read the. Shall I go with the questions directly? Or you
Yeah,
want
yeah,
to read?
yeah. Yeah.
Okay, which one of the following sections of CRPC deals with compoundable offense? 320 of CRPC deals with compoundable offenses. Compounding of offenses. Subsection 1 lists offenses that may be compounded by the person specified in the table without the permission of the court. Subsection 2 lists more serious offenses that may be compounded only with the leave of the court. Offenses not mentioned in either table are non-compoundable. Answer is B. That is section 320. Corresponding section, a provision under BNSS is section 359. 320 of CRPC, 359 of BNSS. The provision related to plea bargaining is not applicable in the following offense. A, socioeconomic offense. B is offense against women. Both A and B, none of the above. D were not applicable, both. Socioeconomic country ki the outundi and offense against women. So this is given in chapter 21A of CRPC, inserted by introduced by all this. You already know all this. So I'm going to the third question. Under section 290 clause 1 of BNSS, within how many days from the date of framing of charges can an accused file for an application of plea by 30 days. Okay.
Yeah.
Next is a provision of plea bargaining under chapter 21A of CRPC are not applicable if the offense is committed against a child below the age of 14 years.
Yeah.
Below the age of 14. Next is under section 320 of CRPC for criminal intimidation. Which section of IPC is applicable? 506. 506. Last point we read. 506 is of IPC. Section 503 of IPC defines criminal intimidation. 506 of IPC prescribes the punishment.
Okay.
So there is one note here. I'll just read the note. Note for 2026 candidates. The IPC has been replaced by the Bharati. We know this. BNS 2023, effective from 1st of July 2024. BNS equivalents of IPC 503, criminal intimidation is 351. And 506 IPC punishment is given in 352. We have to remember these two. This is section 321, 320 clause 1 of CRPC on compoundable offences. BNS is section 379. ఏం గుర్తుంటుందో ఏంటో. Sixth one is section 265A to 265L. This also we read na. Plea bargaining.
Plea bargaining.
Chapter 21A of CRPC deals with plea bargaining. Next, plea bargaining is applicable only in respect of those offences for which punishment is up to a period of 7 years. Should
Yeah.
not should not exceed 7 years. Yes, you have to remember. We
Okay.
are done, no? Still
Yeah,
it's
we're
there.
done for today. We'll do tomorrow. డైలీ ఇలా ఒక హ్యాబిట్ పెట్టుకుంటే మళ్ళీ ఎలాగో మధ్యలో ఇంటర్నల్స్ అని ఇవన్నీ వైవా అని విల్ మిస్ సమ్ డేస్.
Yeah, correct. That's true.
ఇది కొంచెం ఎర్లీగా స్టార్ట్ చేస్తే బాగుంటుందేమో.
డన్ సార్. 8కి చేద్దామా?
8కి అయితే కొంచెం కన్వీనియంట్.
యా, లేకపోతే అందరు నిద్రపోతున్నారు అసలు.
నిద్ర వచ్చేస్తుంది.
సరే సార్, 8కి చేద్దాం రేపు.
అలాగే.
ఓకే, థ్యాంక్ యూ సార్. థ్యాంక్స్.
థ్యాంక్
థ్యాంక్
యూ.
యూ
Thank you, Venu garu. Thank you all.
థ్యాంక్స్ భరద్వాజ్ గారు. థ్యాంక్స్ ఎవ్రీబడి.
Bye.